The Alternative Dig Talk. Real issues, real talk.
Besigye and another coming up formation and ruling of court on issues raised by Council Lord Mayor.
Non, mais c'est des animaux.
And definitely listen down. All I was talking about in the legislative. My name is Bagelias. I'll be addressing this honorable tribune on the issue of the leadership of the team much later. But permit Mr. Chairman to introduce to you Council Ernest Karibara, Asia. Our President Besigye. Rwanda, Chintu Mike, Kato Musile, Kapuri Musile, Sekanjako Abubakar, George William Mukula, Mujiliire Doscovia, Katushabe Ronald, Isaac Wagala, Kabuye Lawrence, Nagoga Miriam, Faruku Kamrege, Kato Wilson, Silas Ogul, Tugume Kebi Moses, Kirumba Robert Tumusime, Kakimpa Godfrey, Samuel Munisi Murinda. As you will be notified, Mr. Chairman and honorable members, we received some disturbing news this morning that he was abducted in the wee hours, and one of our colleagues will substantiate on that, because it's a matter of concern to our legal team. We also have Edwin Kafura, Bowe Ivan, Apollo Katumba is here. And before you are 3 visiting jurists. That is Margaret Nangakovi from Angola. And also, Gicheru Kiremo from Kenya, is a visiting jurist. And Mr. Chairman, last but not least, our team leader, the Lead Council, Martha Wangari Karua, who is before you. Mr. Chairman, there are 2 issues we really need to address. One about the sitting arrangement in this court, because the way we are seated, and I can't even say we are seated, some of our colleagues, you can see, they can't execute their duties effectively under such circumstances when they are standing. And we need to confer from time to time on how to deal with the matter. So there is that housekeeping matter which we thought ought to have been addressed prior to the commencement of the proceedings. Unfortunately, Mr. Chairman, you can see we are really disjointed the way we are seated. And we needed to act as a team because we have all been instructed to deal with this matter. So I request, Mr. Chairman, that you be pleased to direct that matter be addressed. The second issue, Your Worship, is in regard to, Mr. Chairman, is in regard to the Lead Council. The last time we appeared here, we had adjourned on a note that there are processes we are still pursuing, Mr. Chairman, regarding her practicing certificate to be able to have audience before this honorable tribunal. It's actually on that account that this honorable tribunal deemed it necessary to have the proceedings deferred to allow us that time to finalize the process. Where we stand today, the status quo has not changed, Mr. Chairman. There are matters which are still before the Law Council. We have gotten a communication from the Law Council which we would like to share with you, Mr. Chairman, and the response has been made by the senior counsel here. We are waiting their pronouncement on the same or further processes, because we feel this is a matter of great concern to not only the accused persons, but also this honorable tribunal, given its centrality on the constitutional processes in this country. Mr. Chairman, I don't need to delve so much into the provisions of Article 28. Actually, right together with Article 23, the right to fair hearing, and the cornerstone of that particular right, part of it is indeed effective representation of the accused persons. And the accused persons have got a prerogative, which is constitutional in nature, to choose lawyers they deem competent enough to deal with their matter. And under Article 28, this honorable tribunal is enjoined to facilitate the accused persons with all what they require to be able to prepare their defense effectively. And one of the tools they require to effectively prepare their defense is to have a formidable and competent team duly constituted. So in a nutshell, Mr. Chairman, we are still in the process of having our legal team fully constituted, because right now our legal counsel has not been cleared by the law council, and there are two issues that have been raised by the law council, one of which being, Mr. Chairman, the need to prove that there is a value addition she's going to make in this matter, and that will prove that indeed her presence in this matter is critical, is important for effective dispensation of justice. We intend to do that because it has been one of the big issues raised by the law council. The other issue they raised that they have no precedent of this nature where there's been a cross-border practice in criminal matters. That in the history of this country, all the jurisprudence that we have never had a single criminal case attracting a lawyer from a foreign jurisdiction. That is something which is equally fundamental, and we want to establish whether indeed representation by a jurist from a different jurisdiction is restricted to civil matters, because that is a contention within this ruling of the law council. And finally, Mr. Chairman, the question of East Africa integration. Mr. Chairman, allow me, with your permission, Mr. Chairman, I just want to prove to court that the Honorable Martha Karua here holds an East African passport, which is a valid document in Uganda. I think Council Kwaku, we are not going to go this thing. We already knew about the decision of the law council. If there are the way forward, we are grateful to how we are doing. Mr. Chairman, I wasn't advised that the court had read newspapers. So it's the reason I was laying the foundation for this case. I thought court had some evidence, and I wanted to submit this report for record purposes. And with all due respect, I don't know which newspaper I can quote.
Now, being the case, we have talked before our court started, and we agreed that she has to be given a seat, but we will not participate in the proceedings. So if you are the one leading the team, proceed about the case.
Precisely the point I was making, I have not been instructed to lead the team. The instructions to lead the team remain with the Honorable Martha Karua. And that is the point I very much wanted to put on record to guide the proceedings. And with your permission, allow me to submit this document, together with the response given by the Honorable Martha Karua. These documents, for record purposes, the response is here, Mr. Chairman, if you may, for record purposes. So the long and short of it, Mr. Chairman, as I sum up my submissions, the accused persons are still in the process of constituting their legal team, and this is what we are still dealing with. And it's an inalienable right, a non-derogable right under our Constitution, that they must be accorded the right to a fair hearing. They must be accorded the facilities to be able to adequately and effectively prepare their defense. So we are still at that stage, Mr. Chairman and honorable members. I beg to submit. So I will let my colleagues, Mr. Chairman, have them, because I mentioned the abduction of retired Major Iduli and a couple of other issues. I beg to submit, Mr. Chairman.
member of the court, you should advise it and they tell me. You are not a member of the court. You are not a member of the court. You advise court and the court rules. No. You are not a member of the court. It's not a member of the court.
Section 169, UPDF Act,
Read it.
and Section 2.
Read it.
You read that.
No, you can't. You are not court.
We have
Ogulia receive your mujiliire, then
read Section 169 and Section 212. We don't know about that. You when they read for you the law, because you may end up in the wrong house, the wrong today.
Even you may end up there.
What?
No. Is it new?
You know, this is a court. I don't want to hear the word tribunal because it's not under the UPDF Act.
That is guidance that only comes from the court, members of the court, not from a judge advocate.
Listen, Chisa, Section 212, witnesses and advocates at military courts. And I will refer you to subsection 9. Any conduct of an advocate before unit disciplinary committee or court martial that would be liable to censure or be quoted to court if it took place before a civil court is likewise liable to ensure or is contempt of court in the case of a unit disciplinary committee or court martial, and the provisions governing the procedure of unit disciplinary committees or court martial are binding upon an advocate appearing before unit disciplinary committee or court martial, and willful disobedience of provisions shall, if perceived be deemed to be in contempt of court, punishable in accordance with Section 169. So, quote Section 169. Section 9. Then Section 169, offences in respect of military courts. I take you to 1T. Any person who, being an advocate, conducts himself or herself in a manner described in Section 212, subsection 9, will have committed an offense and liable on conviction to imprisonment for a term not exceeding 5 years. So, as you address this court, I'm just giving you another warning that you must read the law. We are in court, we are not on a rally.
Chair, with respect to the provisions read, whatsoever he has read, he cannot in any way determine what we advocates for the defense say. We are not under his command, and no can he determine what court decides.
No, you can say it, but be orderly. You are not going to
because we're going to dictate what council should say on our behalf, and you do not have that right.
So can I read to you the rules? I'm the judge advocate of this court, and I'm the one responsible for making sure that everything moves on procedurally here. You cannot be a judge in your own cause. That's why we're in court here.
The judge in this case, they are the investigator, arrester, prosecutor, judge. What are you talking about?
Where do you get those facts?
Do you want to surprise the facts of abduction? Do you?
So,
Do you want to surprise
Chisa,
them?
you can go ahead and submit. I'll give you them.
So, we are talking. Before the
Take up on my Jikone kone mpi. Jikube kumpi.
Yes, thank you for the guidance that the defense lawyers are working. So, Honorable Chairman and members of this military tribunal, we have three issues which my senior land counsel alluded to, but I will start with the abduction because abduction is a derogation of Article 44, Paragraph C of the 1995 Ugandan Constitution. It is a sacrosanct right that should be not so. I'm not talking about the abduction of the accused persons from Kenya to Uganda and they are in concomitant incommunicado detention, which has resulted into this proceeding. What I'm talking about is that a member of our defense team, retired Major Januart, has been abducted this morning towards 5 a.m. and he's not able to represent Dr. Besigye and Hajji Lutale OBA College, yeah? And that means we are unable, our hands are tied. Our team is complete. Even if it was complete, there's a lot to say about that, but we want to note that we feel that this is a form of intimidation on the legal team. The last time I appeared here in the morning, I found soldiers on my office. I ignored them because if they had touched me, I would have beaten them. But there are some members of this team who don't want an association of soldiers around their offices, around their homes. Major Januart didn't open the door for them. They broke the door and he left the phone on, and his siblings would hear the wreckage reminiscent of the abduction of Kakwenza, how it unfolded. So we hope this Honorable Military Tribunal can rein into the conduct of the military so that we don't have a repetition of this unfortunate development whereby a member of the Lutale and the Besigye defense team is arrested for precisely doing their work. If Iduri had not been arrested, he would be here with us and would be in a much better shape, including even on the knowledge of the rules. Because Iduri, I started practicing with him for this honorable military tribunal in 2014. I have been around. We started in Kasese, one in Bundubujo, one in Jinja, and I'm an old hand at this. We have 3 visiting jurists, and one of them is seated here on the front because she's the team leader. She will not speak, she will not submit when eventually we get to trial, but her right as senior counsel to sit on the bar is untouchable. Then the seating arrangement, Honorable Chairman and members of this military tribunal, we are unable to proceed with any further when our colleagues are standing, because there is no way we can proceed in this fashion. We pray that this honorable court sorts the seating arrangement of our colleagues before, as a defense, we can proceed any further. Thank you.
For record purposes, my name is Hajji Lutale. I rise to express our displeasure as regards the manner we have been treated at the entrance. When we enter here in these premises, we are supposed to be officers of court, and we should be treated as such. However, after here, we go back when we don't need any further gym, any further work. After here, we are so tired. As we talk now, we are extremely tired because of the mistreatment. The soldiers take us through. This should change. Indeed, there is nothing which resembles a court, depending on the conduct of the soldiers out there. Mr. Chairman, it is my humble request that this honorable tribunal benchmarks with the other courts, allow us the permission to treat it as a court. Indeed, the way we are treated, we are right to say that we and our clients are being persecuted. Our clients are not being prosecuted, but rather persecuted. Your soldiers out there are determining who to lead us, where to sit, who speak what. Indeed, we are not grateful with that kind of treatment. This is not what is done in the courts of judicature. Something must be done, Mr. Chairman. As you lead by example, that example must be seen. That is the motto. By example, we lead. That is the UPDF motto. But sincerely, there is nothing to emulate from the conduct of soldiers out there, treating us as if we are criminals, or as if we are convicts. We are not. We are good people, and we love you guys. We love you, soldiers. Don't treat us like that. Tukoye. Thank you.
Register. Honorable Chairman, let's sort out the issue of representation. How many people filed instructions with you? Because
Let me handle. Honorable Chairman, and can I speak? Can I speak? What's your problem?
they have asked the Rogers for not given.
I'm requesting to speak. I'm not imposing myself. No, have you started the camp about
Why are you? We want an answer from the Rogers.
Mr. Chairman, I request we respect the rules regulating court processes. When an advocate is instructed, they have a right of audience. Each of us here were instructed to represent their chosen persons. So even if all the 40 were to speak, they reach no law. So I kindly and humbly request the judge advocate to hold the fire.
No, the issue is we want to know who filed the practicing certificate with the registrar.
But the thing is, We have put the names on record.
We want
those
the-
who are supposed to have audience.
We want the practicing certificates of every advocate appearing here, and it is done in the civil court.
Please, order, please. Honorable Sarukwago, I wanted to talk about that in my just small communication here. When you talked of sitting arrangement, from what the registrar has, he told us 10 people who have fulfilled the requirement. And that's why the arrangement is like that. We expected 10 people, and those who have not fulfilled to be in the seats highly there. Why? First of all, Councillor Babu, you were self, you did what you are supposed to do. Others did not do it. Now what is that? Why is it like that? Why is it like that? So that advocate was asking the registrar to update the code. How many people or who are they who fulfill the requirements? Can you please tell us that?
In prayer, in arrest of that ruling of the Registrar General's thing, reading of the list, because there is a constitutional matter now at play, the right to fair hearing. The last time I checked, Uganda was being governed by a constitution. In section 2 of that article 2 of that constitution, it was binding on all authorities, all persons, including the judge advocate, including this court, every member, and it is to the effect of that constitution that the right to a fair hearing is sacrosanct. That right to a fair hearing includes the accused persons, in this case our clients, choosing their lawyers, the number of the lawyers, and even now as we speak they can add on the number of lawyers. It is not the province of any court in any land, not even the Supreme Court can tell the accused.
Council Chiza, we are not limiting anybody. We are just talking about the procedure.
I am trying to say that that procedure, to the extent that it tries to stop Besigye from hiring a new lawyer right now and submitting it before you, is null and void. And the solution to such a null and void notices is in several provisions of the Constitution. There is 127, 274, and another is 1262. The 1262 says that substantive justice, and there is no justice more substantive than the right of a lawyer, the right of an accused to choose their lawyer. And that right, when I say it is sacrosanct, I mean it cannot be modified by anyone, not even the President of the Republic of Uganda can modify the right to a fair hearing. Right now, even as we are speaking, we can substitute counsel. As we speak, we can get a new counsel. So the idea of 48-hour notice, we reject it as null and void. Family, we are not. The fact that me and Rukwago brought a notice does not mean that we are amending the constitution of the Uganda. That was a bonus, and since the accused have since added on the lawyers, and no one can tell the accused which lawyers to appear today. That's why we are unable to proceed without our colleagues.
Mr. Chairman, if I can proceed. Maybe if the issue before this tribunal is about whether one qualifies to be an advocate and to have audience before you, it should be clear, and I have my practicing certificate with me here. I can provide it to this court. Two, I raised on an issue that is very clear. Under the Constitution, the formation of the UPDF, and Article 208, I will go to 2, that the Uganda People's Defense Forces shall be non-partisan, national in character, patriotic, professional, disciplined, productive, and subordinate to the civilian authority as established under this Constitution. will form part of the civilians. Mr. Chairman of the tribunal. 2. Clause 3 is that members of the Uganda People's Defense Forces shall be citizens of Uganda and of good character. Mr. Chairman and your tribunal, the character depicted by the members at your entrance there is not of good character. Secondly, I can see you have your name tags on your uniforms, including these people.
Those issues, I don't think that's why we are here. First of all, we are sorting out the issue of advocates.
Yes,
Honorable Kwabo said people are standing. You are going taking us astray.
Advocate Judge, let me address my issue, then you can respond.
No, because that issue,
because this is a very sensitive issue.
Councillor has talked about it.
With all due respect, my issue is a different issue. It's about identification of the people that you put at the center as we enter. You can't know who manhandled me, who battered me, and you should act as good examples to the rest of the people. You are people with superior powers to guide the professionalism and conduct of the people. Why can't that be sorted so that we know who is addressing us and at what time by putting on their name tag to them? I think.
Council, you have heard about the conduct, and I have heard from your side. I will interact with those people at the gate who are manning the security. I believe that one will be solved.
Registrar still, you have said you have your PC. I don't think anybody is going to put on a suit and a tie and come here and serve a lawyer. So we are going to prove that by a PC. If you don't have a PC filed with the registrar, we shall not recognize you in this court.
Mr. Chairman, we take exception. Lawyers are certified to appear in any court once they are on record. So if you are in doubt whether one has got a PC, that can always be addressed. But it's not that every time we come here, we brandish our PCs. Here it is, here it is, here it is.
There are those who have not submitted.
Let's enter the issue. So there is what we call a digital system in the court. Even if you want to know the lawyers who are entitled to practice, you can Google them. The Uganda Law Society website. They are public, are available. That should not be a problem. It's not a problem of their choosing. I think whoever is trying to create that problem should deal with it, but the accused has chosen competent lawyers, and whoever is in doubt of their qualifications should Google them.
And for any doubt, they can proceed to the law council for those who need help.
He who alleges must prove. I'm alleging that you are saying you are not advocate, you have to ask not a PC, and it's not negotiable by the way.
Should rate the chief register is the only person who gives us licenses. Should rate to the chief register. The names are available. They were available 3 times on the gate as we are being searched, as we are entering this courtroom. So we cannot provide several times. How many times are we going to provide? The ball is in your tribunal. Then the answer of that is the judge has say, I have scrutinized the chief register by the letter, and the letter is submitted saying this one and this one are not ordered. That is not so. It is not him that is an attack because he does not hold the wrong hand.
I don't hold it, but I am moving under the regulations governing the court.
Not the certifying authority. To certify whether somebody's PC is legible or not.
Anyway, the matter is simple, and my guidance is final. I'm telling you, you have to find your PCs with the registrar. That is.
Somebody is now kidnapping
Chairman, Mr. Chairman, we wish to hear the pronouncement of court on that, whether the interpretation by the judge advocate is final and is binding on all this court and on all of us, whether it is ill-advised or not, is misconceived or not. We need to get a position on that, because otherwise that would be violation of the principles of fair hearing, because we are here to be heard by the and the decision made.
For avoidance of doubt, we do not need to hear from the chairman to know that the judge advocate is misleading court. The primary character, the defining feature of any tribunal, including quasi-judicial tribunals, is judicial independence. If a tribunal is telling us that it is not independent, that whatever the judge advocate says, they will swallow it hook, line, and sinker, then we have no business here.
Getting the word tribunal. We don't have a tribunal here.
I don't know how many times I will tell you that this is a military tribunal. There is a dictionary, you can look it up. The meaning of tribunal. I'm getting tired.
I think, Council Bago, we are not doing this honestly. Because I don't see what harm does it make you to follow the procedure and bring your PC and the instructions to registrar so that we know people we are dealing with. What's wrong with that? Why do we waste time on this?
Because, Honorable Chairman, we have put it in black and white. We have put ink to paper. We have.
And you are asking court to find out, to go on Google and find out whether you are practicing or doing what?
In the cases where
what you all came from your family, why did you come in the court and file in the
Chairman, in the cases where the court doesn't want to Google, they formally write to the chief registrar of the courts of judicature, and the chief registrar writes back indicating that this person is not enrolled or licensed for this year, or he is. That is how the procedure for courts that was there sort to do.
You talked of Major who was arrested or
abducted. Retired Major Iduri was abducted a few minutes towards 5 a.m. this morning by members of the Joint Security Team, including the military, to which this military tribunal belongs. And that's why we are using the good offices.
It's good you know who arrested him. I think you can either approach them or pressurize them to produce him to court so that you can start from there. Otherwise,
our complaint, Your Honor, is that, Mr. Chairman, is that he is a member of the defense team. The reason this team is incomplete is because he has been abducted by members of UPDF.
And that's what I'm saying. It's good you know who arrested them. Members of UPDF, I think there are many departments. I don't know who arrested him. Is it the court or is it the... Who arrested him?
Not the court.
Who arrested
They are like
him?
the ones we met there without stamps. The guys we met at the gate, they are also like them. They are without stamps. Some of them are... Yes, it's a nasty situation. Your Honor, when abduction is terrible.
Since you know them, that's what you can handle.
We are military strangers. We just know they are military men, but they are not identifiable.
If he's brought here, then we will listen. And Councillor Bago, you again talked about the lead council, Madame Kalu, I think, who is not cleared. not cleared by the Law Council, according to the document you have presented here. So before she's not cleared, I don't know what you have. Can you read the team or not?
Chair and honorable members, I unequivocally stated that the prerogative rests with the accused persons to choose who leads the team. But from the instructions we got from council here, the Law Council, if I may read page 3 of page 6, paragraph G. The Law Council is composed of members who have full-time jobs in other government agencies and as private practitioners. They require adequate notice in order to meet and consider applications. We believe they have not had ample time to canvass all the issues they needed to deal with, given that statement. So it would be premature for any decision to be taken at this stage before we exhaust all these processes. We believe the Law Council, in making that statement, they wanted to get more time to deal with this. Never mind that they indicated some issues which we find objectionable, like the political connotations and other matters, which we can put squarely to them. And as I indicated earlier, Chairman, the Honorable Martha Karu has made a strong rebuttal to all the issues that have been raised here, which has been served on the Law Council. We are yet to be favored by a response. We believe now that there is a rebuttal and the issues they were raising have been adequately responded to. They are going to reconvene and take an appropriate decision. So this is, we are saying, on the understanding that the accused persons have got a right to constitute a legal team to defend them. The right to legal representation is sacrosanct, is non-derogable. That is the whole point. And they want to have an effective team. And these are not the usual proceedings we have, Mr. Chairman. Because if it was just an ordinary case where you are trying a matter which does not cut across different jurisdictions, Mr. Chairman, the charge sheet is very clear. The accused were picked from a totally different jurisdiction, Kenya. And they were brought here without going through the due process, without an extradition order, without a deportation order. So the jurisdiction where they are picked from is where you are having the senior counsel coming from. And that is the reason we find strange the reasoning advanced by the Law Council that they don't expect any special skill the senior counsel is going to bring onto this matter. Maybe they were oblivious of these facts, but now that there is a rebuttal, we are confident that they are going to reconsider this matter. So I cannot arrogate myself the duty of leading counsel when the instructions are on the contract. I thank you, Mr. Chairman.
It's okay, counsel. If that process is finalized, we will follow you here. So you wanted to say anything?
Okay, no, hey, you didn't have a leader of opposition, Honorable Mpunga, Honorable
I'm not at the head, but from my own observation, when you look at our colleagues, how they are conducting themselves before this court, and when they are now confronting those young boys, what do you expect? If they can behave the way they are behaving when they are here, what about those small boys? So the approach must change. Their approach. Then my prayer to this court is that which council is saying is not court but it's a court matter. It's not a court. My colleague, Councillor Kwako, has been appearing on so many media and discussing the merits of this case. This court has no jurisdiction. The charge sheet is from the other. I think it's involved by this application. Matters before court is going to be discussed. And I've seen several times, including in eLuzira, who is referring to this court as criminals. My understanding of criminals.
Can I substantiate myself? No, it is you sit down. When I read, if you are a lawyer who went to law school, sit down, don't waste our time. If I stand up, you sit, it's automatic. So, no, that is okay. Then you need the land from this land before. No.
When they were talking,
you see, when a lawyer stands up, you sit automatically, you need the land back in school.
Why don't you be patient? Submit and then you are given time.
You don't just mention eLuzira fast. No. Stay up. Stay up. Yes, I'm possessed of wisdom and knowledge. Yes. Yes, I'm possessed. I'm happy to recognize it.
Can you listen?
you are under you don't just move to the or go to the pastors or which one. And I do believe that council you know where you are supposed to take your grievances. Why did you just go to the public? Why do you get to just complaints to the public? Why don't, if you are in agreement with the budget, you know you are supposed to go to another court. The other time you appeared here, you first made press-ups outside the court. Why are you doing this profession? What profession do you do to us? When you thought the 5 years we're talking about, when you thought that you must first make press-ups before you go to court, how is your money? Why you can't sweat in? And by your studies, you are supposed to take a shower. You come to where you are, just for a stay. And you say, you started to go for 5 years. I called the act before you were doing it. You come to the constitution, you say it was for academic. So, please run for avoid those actions that you are doing. Come when you are proposing and when you are prepared to proceed with the matter. So I pray that these people be restrained from talking about the matter which is before God. You can see some I can hear the representatives, some will hear the lawyers. I've not had him talking, and I think he's waiting for evidence. But some people come here just to make a show. Ernest Karibara is here. He's a respected lawyer. I've not seen him making any noise. Trying to show this. No, he's waiting for evidence, not at all. So I pray that these lawyers get restrained from discussing the matters, especially touching evidence. So if you go with the charge to the public, so what will the public do? They are going to what the pastors and that will be the direction. So in regarding my question, I wanted to hear this of saying this person was abducted and no, we are not having the person before here who was abducted. The legal process was followed. There is this African protocol allows us to enter into various arrangements and engagements. And among those engagements, there is a memorandum of understanding between the Republic of Uganda and the Republic of Kenya on cooperation in defense and security matters. And under that arrangement, it is where we have the two accused persons before this court. There is a paragraph.
I am objecting to your conduct. We are not yet at that point. We have sorted out issues raised by counsel. There is not even disclosure of what you're stating.
No.
Not waste our time by proceeding.
Don't waste our time.
No.
Don't waste our time. Either you share it or you sit down. No, we need a copy. We need a copy of that.
We are objecting to your conduct.
Look at how you are conducting yourself. So I was saying that under this arrangement, that is paragraph. Some paragraph. My prayer is let those who are involved in this matter be restrained from discussing this case. The case before this court can be filed. The variety of evidence, the charge sheet is defective. The charge sheet, if the charge sheet is defective, you know where to take it. It's not the public that is going to find it. Chairman, I pray that these people will frustrate the subject is wrong.
And it was going to say, let them be arrested.
We have a response to the application. Before us and chairman. It has not been anything grounded on matters of law. I believe he attempted to submit on issues of sub-judice. I hope he had come adequately prepared to make his own submission on that particular matter. Because there is a wealth of authorities on the rule of sub-judice, and he has not cited any of the authorities or principle or anything. But if I may help him on this, the rule of sub-judice, Mr. Chairman, is not absolute. It's structured in such a way that one shall not discuss a matter which is before court in a manner that is likely to prejudice the outcome of the case. It is qualified in a manner that is likely to prejudice the outcome of the case. That is one. Two, to discuss a matter which is before a court of competent record, a court of judicature. If matters are before a disciplinary committee, for example, they are before a tribunal, they are before an LC court. I'm not suggesting this is one. And I request you take it in good faith, Mr. Chairman. I'm just giving an example. So the rule of sub judice is not of universal application. It's about courts of judicature. So if it's a matter which is before the General Court Martial, which is not a court of judicature, which is not a court of competent record, you would have come to there with authorities to stretch the application of that rule to the proceedings here. And I make those submissions were advised that they are good authorities to that effect. We are not expecting him to raise it. But that said, Mr. Chairman, again, the rule does not bar anyone, not even advocates, not even members of the public, to discuss decided cases. He talked about our continued pronouncement of the trial of civilians before the General Court Martial. There is a court decision to that effect. So it's not a matter which is sub judice, whether civilians should be tried before a General Court Martial or not. It's a decided matter. If he interested himself in the decision of Kabasiguruka, a copy of which Council Tugume can show him, we have a very big decision. It is there, a huge one, about that. So if we are interpreting a decision of the Constitutional Court, we are not breaching any rule of sub judice. I am at liberty at any given moment, any given time, any given forum to interpret the decision of the Constitutional Court. I breach no law. What is pending before the Supreme Court is the appeal. So if I make a demand that the Chief Justice should render a decision which has been long overdue, with the commitment that was made in a ruling that I can share with you, I have a copy here, Mr. Chairman. Get me a copy. I am preaching no rule whatsoever. So if I read out, and these are things, these are matters we have said time and again on media and elsewhere. And this ruling here, Mr. Chairman, in the Attorney General versus Honorable Michael Kabasiguruka, the Right Honorable Chief Justice here and the justices of the Supreme Court, in decision number 4, they said, owing to the matter in contention for which the appeal has now been filed, being one of great public importance, the appeal shall be accorded urgency and shall be immediately fixed for hearing, dated the 5th August 2021. So, Mr. Chairman, when we stand out in the public and demand that the Chief Justice should honor the dictate of this ruling, the decision they made that this appeal should be disposed of expeditiously, we are actually asserting the rights of Ugandans in the Bill of Rights in Chapter 4. Because matters touching the Constitution, matters touching personal liberties, rights, take a precedence over any other matter. So these are the issues we have been discussing, and by now, the point I wanted to emphasize, the position of court now, which has not been set aside, and which we can freely discuss
is that this honorable court has no jurisdiction to try civilians. That is the decision of the constitutional court, which has not been set aside. So if I repeat it, I'm breaching no law, and no court can stop me from saying that. So that is as far as that issue is concerned. The other issue is talking about, and the last one, is about, again, matters in the public domain. Mr. Chairman, we are really shocked that the prosecutor here is talking about the defense, when indeed actually the application should be in regard to the state. The application to restrain any of the parties in this indulging in the merits of the matter, actually that order should be directed to the state. Why? Because they have already started trying this matter in the court of public opinion. Getting audio clips which are purportedly said to be emanating from UPDF, being even transcribed verbatim in one of the dailies here and a number of other media houses. This is prejudicial to this matter. Actually, it is choreographed to condition the public out there and the international community that these accused persons here stand guilty. Contrary to the foundation of our constitution that thou shalt not be treated as a convict until proved otherwise. Now the state is already trying them in the court of public opinion. And he has not come out to condemn that and to ask any application for court to restrain them. What a shame. So, Mr. Chairman, I want to conclude by asking that those issues he's raising shouldn't be entertained. Here, what needs to be done at this material time is for us to have the team of lawyers, because we are still considering the preliminary matters. Those are the preliminary matters we raised. We want to constitute our team fully and be able to proceed with the matter as and when we are ready to proceed. So I beg, Mr. Chairman, that the application he has raised, and to me in particular, you see he mentioned my name, and I wish he cited anywhere where I featured and offended the rules, but that is besides the point. But if I may also ask him, as I conclude, Mr. Chairman, is he asking for orders to restrain debate worldwide? Because this matter is not only restricted to the confines of Uganda. It is on CNN, on Al-Jazeera, on KKNTC, it is everywhere being discussed. So, of what I don't know, the confines of the orders, whether this General Court Martial has got orders to order the world never to talk about Dr. Besigye case until a decision is rendered. So that would be really outrageous with all due respect. It would be absurd and it shouldn't be entertained. I beg to move, Mr. Chairman.
I will be very pithy, and I like the wandering Jew that raised these matters. One, media has media freedom. We are not going to discuss it. If people didn't understand it, it's too late. Pastors, going to a pastor is a function of religious freedom. It is outlined in the Constitution. It's a human rights in the language. Going to witchcraft, if I wanted witchcraft, I would have gone to Raphael. I didn't. Where to take grievances, yes, I know. Press-ups, I want to be healthy. I don't want to look like some people. About the profession, yes, I'm an honorary member of the profession, and on civil society, the Uganda Law Society has recognized me. About rhetoric, I know we can't get into poetry. We are here to discuss law. So I still leave the rhetoric to him. The word promulgated means bringing into effect. Laws are promulgated. I don't know what the I mean, I am not responsible for the inability of the prosecutor to understand what I'm saying. I am not responsible. There are some things that on the prayers of Brisbane, that one I will not dignify the comment. On prejudice, he needs to address himself to Article 29 of the Constitution before he submits on prejudice. He hasn't. Has he? No. The charge sheet, yes, it is a public document because there is an assumption that a quasi-tribunal is a public body whose documents can be shared. We shall continue sharing charge sheets in WhatsApp, with media, on mic, that it's even there, you will not remove it. And we shall debate it. Abduction, it is a fact, you can't pray for it. You abducted. The people here, these two people are a product of extraterritorial abduction and extraordinary rendition. Those are the English terms. If any breakdown is needed, I am ready. These are victims of abduction, of heinous kidnapping. They are here because some soldiers committed crime in Kenya on the 16th of November. Those soldiers have not been brought to book, and tomorrow I'm going to write to the CDF to give me names of the criminals who brought Besigye and Lutale here in the breach of Kenyan law, of Ugandan law, and East African Community law, and the African Charter on Human and People's Rights, and the Universal Declaration of Human Rights, and the International Covenant on Civil and Political Rights, on the Convention Against Torture, and other legal instruments. Raphael will not stop that. That's a discussion between me and the CDF. It's above you. Kidnap, abduction are crimes under the laws of Uganda. No member no citizen of Uganda should be here to drum support for kidnap and abduction. The duty of anyone who has witnessed abduction in community detention is to report to police or appropriate authorities. This should be the last time that someone is raising in this court, in this matter, tribunal to support abduction. We should all condemn it. The memoranda he was trying to read is a secret. There is no law which is a secret. Laws must be gazetted. Whatever you are reading is null and void. So yeah, indeed, these are older men. The last time I checked, Besigye was around 68. Lutale was crossing nearby. So if you are going to hold old men standing for these hours as lawyers under the law, or what looks like law, it's going to be unfortunate. I mean, what looks like in the case of Raphael. It is also unjust that our colleagues, we have raised it, we are unable to proceed further because we cannot proceed when our colleagues have nowhere to sit. It vindicates those who say that this is a kangaroo court. Kangaroo means unfair in case someone doesn't understand it, and I know who will not understand it.
Mr. Chairman, in just 2 sentences, I will have read myself. Mr. Chairman, the prosecutor is inviting you to restrain our freedom of speech without any evidence, without any justification, without any basis. He is blackmailing us, Mr. Chairman. I believe you have heard from his statements, attacking even our conduct from outside this tribunal, Mr. Chairman. For instance, when he cited the press-ups which were made by my land friend. Mr. Chairman, I invite this tribunal to treat his submissions as mere statements from the bar. The same should be disregarded as being without procedural or evidential value. Mr. Chairman, overrule the prosecutor. Mr. Chairman, don't grant the orders he's seeking. Mr. Chairman, the prosecutor is inviting you to infringe the provisions of the Constitution. Mr. Chairman, you and your tribunal must uphold the provisions of the Constitution. Mr. Chairman, we are not at that level where we may be considered to have moved against the principle of res sub judice. Mr. Chairman, I beg that you disregard all the prayers made by the prosecutor. I beg to rest.
Mr. Chairman, with all due respect to the state here, I made a comment about the discipline and how we are mistreated at the entrance. And he claims that it is because of our conduct, which is not clear. We are told to identify ourselves. We do identify ourselves before you access these premises. This is a public court. As we speak now, you can look at the men here in uniform, without name tags, even when the space is provided for. We are here, they have introduced ourselves. You have name tags on your uniforms, why are they here? Our security here should be paramount as a public place. That should not be an issue of Council Raphael to discuss here. It should be clear and court with all its powers, the tribunal. Through you, Mr. Chairman, you should make that order and directive, and it should be complied with, so that we ensure that we are secure and safe even when we are speaking in this. Thank you.
You are very secure, Council. Anything? You want to look again?
My Lord Chairman and honorable court members, we have a brief rejoinder, especially what was raised by Land Council, Mr. Rukwago. My Lord Chairman, as far as the jurisdiction of this court is concerned, my Lord Chairman, also we rely on the decision of the Supreme Court.
Have respect for counsel on the other side. If there is an objection, you should listen.
Joseph
Listen to objection.
against
Please sit down, we are raising on the matter of objection. You know the procedure.
It's a 2005 decision.
Objection. Please sit down. Sit down. Sit down. Sit down.
Much of that, Lord Chairman, is saying that we rely on the decision of Hajji Joseph, the Attorney General, 2005 decision, in as far as much of that
in regard to the issue of sub-judice.
And my Lord Chairman, with due respect to my senior colleague, I pray that please respect, because I wouldn't want to exchange with my senior. I have a little respect for him. But be as it may, my Lord Chairman, I was submitting that one, we ran the decision of the Supreme Court that Hajji Joseph was Attorney General. It's a 2005 decision in as far as pronouncing itself on this court. But also, Lord Chairman, On the decision of Kabasikuruka, my chairman, we have a ruling which I
please stop taking us on a wayward voyage to self-delusion.
And my own chairman, if I may read verbatim, as part of the ruling
Our defense team is not fully constituted. So we have no instructions to proceed in respect of the substance of this matter until when our defense team is fully constituted, Mr. Chairman. All we can seek is to have maybe this matter adjourned to another date or any other business, but not concerning this matter. If the prosecutors withdraw their charges against our clients, we have no problem. We shall oblige, Mr. Chairman. I thank you, but we cannot continue discussing or submitting on the substance of this matter. It's premature. I thank you, Mr. Chairman.
Thank you, Councillor. They raised discussing court matters in the media. Then the council submitted, and I don't know what if state that's what we are going to make a rejoinder of.
Yes, that's
on that one, so that court can rule on that.
Was about the application was making just us to debate this matter in public, and we responded. Now he is raising new matters which were never covered in the application, and for which we have no capacity as material science to handle before we deal with the question of representation. Yes, that's what we want to first.
So, State, if you are making the bill of that one,
who raised the issue of Kabasikuruka. We have not talked about it.
have rejoinder on the objection chairman.
Mr. Chairman, Mr. Chairman, before he makes a rejoinder on whatever, we need to sort out, excuse me, we need to sort out the issue of representation before we go any further. Because we have no instructions to proceed beyond this point.
And wait for the deputy. And we have the matter adjourned because they are saying they are not ready to proceed. That's all. You have a date posted. A date, yes.
Can we have it mentioned like in the West side? The West side, we go and pursue our matters. There was a good and we were sitting there going forward.
The prosecutor is failing to understand us. We have no instructions to proceed beyond this point until we have sorted out the representation of the accused persons. If that is difficult to understand, I will use vernacular. Mr. Chairman, if I may, with all due honor, my name is Ronald. I want to apply to be a friend of this court. Having seen the dilemma we find ourselves in, all the way from judge advocate, senior prosecutor, and what the defense is going through. I want to apply to be amicus curiae in this matter. Because there are some constitutional issues and human rights issues, and it is on that basis that the court can admit us amicus curiae, so that we can resolve the unwarranted procedural issues that are engaging us wantonly at this moment. I pray. Honorable Chairman, we cannot respond to that, and we are not interested in any ruling on that. For us, we have no instructions to proceed on anything before we conclude the issue of representation, whereby our lead counsel must be Martha Karua from Kenya.
We then reject the application of having amicus curiae.
My Lord, we cannot proceed with that, not even with objections. We need the issue of representation sorted out first. The accused have a right to fair hearing. We pray for Chairman, we are praying for 1 week from now.
case is a state case. They are the ones to apply for a debt.
I do believe even when you are given one witness, you will not be very fair. We pray that the case be adjourned. The statement of January 7th January 2022.
Mr. Chairman. And also, we have processes to pursue before the law council, involving the lead council here and others, so that we have them expedited and come back here on the 17th. We move on to another stage. So to talk of 7th January, I think our land friend here wants early Christmas.
No, Council, I think let's give you enough time because it seems whenever you come now, you come to Alex to get enough time, prepare yourselves, and then we proceed. I think 7th January is enough. With that, Colonel retired Dr. Chiza and your colleague, your case is adjourned to 7th January 2025 for further mention. The same time, 10.
You can see the environment is not conducive for dispensation of justice. Whatever is happening here, we have said before and we want to repeat it, is a travesty of justice, it's a mockery of justice, it's a violation of our constitution and all international instruments regarding fair trial, fair hearing and administration of justice. The team from across Africa, we are very, very much appreciative and we are determined to push for the clearance of all the lawyers coming from other jurisdictions to beef up our team. They wanted to frustrate us, to suffocate the process, to stop the Honorable Martha Karua here from leading the team. But we are determined, as you witnessed today, we insisted the proceedings will not continue unless the lead counsel has been cleared. From here, we are going to design more. We are retreating back after here. We are retreating back as a team and the leaders to work out and weave out other measures of ensuring that we get our lead counsel cleared. The law council must understand one thing. This is East Africa. The law council must understand one thing. Dr. Besigye and Obed have got a right to legal representation to get lawyers of their choice, and this is a non-derogable right under the Constitution. We are not changing the position. The lead counsel is Martha Karua. She will continue to lead us until we get justice. That is it. No retreat, no surrender. Thank you. Ngabwe mulabye ebigenda maaso wano gye bayita katemba mu kooti siwali bwenkanya mubalabye abalamuzi bwe batudde eri ng'abalamuzi naye eyeefudde judge advocate ye yeeyitanga omulamuzi atuuse n'agamba n'ogamba ye kyasalawo kyekisembayo. In fact judge advocate ye mulamuzi n'oli prosecutor atuuse n'okugamba abo bonna mubagambe tebaddamu n'okwogera ku musango tebakola ki kwegamba ng'olaba nti
kooti si kooti naye kangalu. Ne tuli bamativu nti tuli wamu ng'ekitole nga bwe mutulabye wano. Jo statement eyakoleddwa tujeyanza nnyo nga tiimu ekulembeddemu leader of opposition wano ng'ekulembeddwamu leadership ya NUP n'abakulembeze abalala. Jenno baani bonna ffenna abali wano. Naye tiimu eyavudde ebweru ey'abannamateeka tujeyanzizza nnyo. Olwaleero Martha Karua ali wano. Tugambye kooti nti ya Dr. Besigye n'Obed be balina right mu ssemateeka okusalawo ani akulembera tiimu. Tetulina liida mulala. Omukulembeze waffe akulembera ligo tiimu eno. Kapiteeni waffe ye Honorable Martha Karua. Tweyanza nnyo ne Nana Kovi all the way from Angola ne council from Kenya n'abalala abagenda okujja. Era tugenda kati mu law council okwatagana ne law council. Twagala law society ne agencies endala zonna zituyambeko. Tulina okufuna certificate ya Martha Karua mu mbeera yonna omusango guno okugenda mu maaso, kubanga ye lead council waffe ate era nga n'emisango bagamba pisto bazisanga ne Dr. Besigye mu Kenya. Bagamba bagiriza Athens Ruda olwaki ogoba baleera abaava ebweru nga Dr. Besigye bamukwatira bweru. Ekyo tetujja kukikkiriza. Asabe leader of opposition ajja kutubaayo statement gye n'omuntu then lead council akurawuninga ako.
Okay, today, 10th December, is International Human Rights Day. This was after the UN General Assembly adopted the Universal Declaration of Human Rights. It is so profound that on a day like this, when we are meant to be celebrating and ensuring that the human rights of all individuals in this our country are respected, we are here because of a violation of human rights of Dr. Kizza Besigye, of Hajji, Obed Kamulegeya, and other Ugandans that have been through this court that have suffered persecution of this military court. It is good that now, as the opposition, we are persecuted together. As NUP, we have had several of our supporters that have been persecuted by this court and several other opposition leaders. Now it is Dr. Kizza Besigye. We are saying we are united against this injustice. And that's why we are here, to say no to this injustice, to say human rights must be respected. It is not okay, and they want to make it okay that they can persecute some of us and the rest of us move on as if it's business as usual. No. And we're calling upon all Ugandans out there. This should actually not just be a matter of the opposition. Some colleagues in the NRM have been persecuted too, freed by courts of law and they are rearrested and so on. So any lover of human rights in this our country, any lover of peace, should be behind the quest to see that we clip the wings of this military court. It should cease to operate the way it does. Olunaku olwaleero mu nsi yonna tujjukira ekiyitibwa International Human Rights Day, kubanga UN General Assembly yagazeetinga olunaku luno. Kitegeeza nti tuba tulina kubanga tujaguza nti eddembe ly'obuntu litwalibwa ng'ekikulu, naye tuli wano ku lunaku luno olwa International Human Rights Day kubanga ate eddembe ly'abannaffe abamu lityoboolebwa. Eddembe lya Dr. Kizza Besigye, Hajji Obed Kamulegeya ne bannayuganda abalala abazze batulugunyizibwa kkooti eno. Kirungi nti ffe nga ab'opposition tuzze katutandise okukwatira awamu ku nsonga zino tugamba nti bwe munaatulugunya omu ku ffe, ffenna kijja tukwatako, kubanga kyekize kitubeerako ffenna abawagizi baffe nga NUP bazze batulugunyizibwa kkooti eno ne bannayuganda abalala. Era nga tukuba omulanga eri bannayuganda tewetaaga kubeerawo opposition n'aba NRM nammwe bajja batulugunya olunaku lwammwe lujja kutuuka bwe mutaasitukiremu ne mugaa nti eddembe ly'abannansi lirina okuteekebwa mu nkola era okutwalibwa ng'ekikulu. Mwebale nnyo. General Muntu. You want to come in the middle maybe? Yeah.
Well, let me first thank the defense lawyers for standing firm and together to ensure that our colleagues Honorable Dr. Chiza Besigye and Hajji Obed Kamrege that their rights to choose who represents them stands. I think today the statement the defense has made is good, and all peace-loving Ugandans, all Ugandans who want to see the rule of law need to understand that 2001, when Januart 7 had an electoral case in court, he was represented by Kaminwa. Kaminwa is a Kenyan. He had 100 lawyers on his team. As precedent. 2 weeks ago, I saw a panel of leaders of East Africa, presidents. Januart 7 was one of those. He's fond of talking about integration. I saw him doing analysis of what has caused weakness on this continent, and he was referring to the chiefs of the past, which he does all the time. For East Africa to be united, for Africa to be united, leadership at the top is very, very critical. You walk the talk. You don't say all the nice things, and your actions contradict what you talk about in public. There's absolutely no reason why, when Dr. Chiza Besigye and Hajji Obed Kamrege choose to have Honorable Martha Karua to be the lead counsel, and it becomes a problem. I absolutely don't see any reason why. But every cloud has a silver lining. Our colleagues now are going to be in prison maybe for the next, but by 7th of January, it could have been like 2 months. Of course, they're going through a lot of pain. The silver lining in that you've stood firm, keeps on exposing this government to masquerade in life is not good. When you are masquerading, the longer a process takes, the more your real colors come out. Because people see contradiction between theory, what you talk about, and practice, what you do. So much as the two colleagues are going to suffer, it's good that time keeps on exposing these people in government. My advice, those who are in government, many of whom are colleagues because we serve together, no government is permanent. All of them leave power at some point. So I keep repeating what I keep raising all the time. When you arrest a retired officer, Major Iduri, he served honorably in the military. He retired. He has a right to represent whoever contracts him to represent him. You go and abduct him. I would like to ask all the officers who are in uniform, including the generals at the top, what do you think? When you honorably serve, many of them have been shot at, many of them have been wounded. They have continued serving this country because many of them love to see justice, love to see peace, love to see a country which is developing. But when you have served and you have left, your own colleagues who are still in uniform come and treat you the way they treated that major. I don't even know him, I've never interacted with him. What does that mean to you who are still in uniform? What does that mean? That you make sacrifices for a country. That even when you get out of uniform, you have got rights like any other individual. You don't have to be on the side of the regime. You do whatever you want to do. That's the country we want to see. My advice, those who are in government, be sure that as day follows night, there's going to be a day when you want to be in those offices. I appeal to you, do things now when you are still in government that will enable you to leave uniform and offices, ministries, whatever, so that you can find a country where there is justice. Whatever you are doing, that you have got rights and freedoms that are going to be protected by the law, not by any individual. Not by any individual. We thank you, members of the press.
Thank you.
Right is might. That's what many people don't understand. Right is might. So the Ugandans who are terrified and they keep on withdrawing and say, oh, things are dragging on, things are dragging on. This is our country. This is our country. The only way we can shape the future to be as we desire it to be is to keep firm, including those who are in government. And to our, it's unfortunate this happened in a neighboring country, Kenya, which we have all always felt secure in. What they did now, imagine, exemplifies what happened more than 30 years ago. But that's the last time a senior politician was abducted from Kenya. That was the late Mzee Barakiria in Nairobi. That was the second UPC government. When they abducted him from Nairobi, we know, those of us who were in the bush by that time, all our external committees scattered. They all ran out of Nairobi and they went to Sweden. They need to ask themselves, really, you want the same thing to happen 30 years thereafter? Finally, I see the law of cumulative effect unfolding. So we should not lose heart. Even those who are in Syria, for 50 years, never thought that Assad and his family would ever get out of power. But 1 week is nowhere to be seen. That's what the law of cumulative effect does. Those who are in government need to understand how it operates. Those who understand how it operates, I suspect will sober up. May God bless you all.
Thank you. Can you, before she takes over, just say one word about retired Major Iduli, because it's about liberties. Just something little small. Something small about Iduli.
In the wee hours of this morning, as the defense team, which was burning the midnight candle to represent Lutale and Besigye, finalized plans to come here and do a robust defense work, some criminals from UPDF abducted retired Major Ronald Iduli from his home in Werenga and disappeared him with the sole purpose of frustrating the defense team of Besigye and Lutale. We condemn that in the strongest terms possible, and we have urged the chairman of this military tribunal that if this is not to be projected as the kangaroo military tribunal it is, then they should restrain members of the UPDF from abducting members of our team. That is not the first threat against members of our team. We have been ignoring some signs of intimidation or directed towards the defense team, and we shall continue to ignore those methods. But we must assert the right of their choosing to a fair hearing, to a fair representation, to dignified treatment, to their liberties as guaranteed by the 1995 Ugandan Constitution. And we are not intimidated. We are not bullied. We shall come here in this military barracks surrounded by soldiers and continue to do the work of representing our people. We have also the grievance of being denied where to sit. Most of our lawyers today were not able even to get seats, and we have not even concluded the issue of representation because both the military tribunal is in cahoots with Museveni and the Law Council of Uganda and illegally trying to block the visiting jurists from Kenya from representing Besigye contrary to his sacrosanct right to choose who represents him as a lawyer, how many lawyers represent him. So we are going to continue fighting these battles on all fronts. There is an all-out legal war against the injustice that has been meted out against our clients, and we shall keep you posted. Thank you very much.
Okay, very briefly.
Oh, sorry. I want to give you space.
I want to first salute the Ugandan opposition for the solidarity. Ugandan members of the bar, that is the legal councils, who have teamed up to represent Kizza Besigye and Mr. Lutale. That solidarity is needed in the wake of aggression and dictatorial tendencies. Now, you have witnessed for yourself, for the longest time when we started this press conference, a military police vehicle standing here with the siren on to obstruct. It has now moved away. You can see it has not gone anywhere. It is now neatly parked. Why couldn't they park to give us silence before? These are the forms of aggression that are happening daily, from obstruction to access. Yes, I was denied the certificate to practice by the Law Council. I am contesting that, not for myself. As my colleagues have said, what we are pushing is the right of Dr. Kizza Besigye and Mr. Lutale to have a team of lawyers of their choice and to have a lead counsel of their choice. That is what we shall be pushing, and that is what the Law Council must consider. Not about me, but the right to counsel and counsels of choice. I want to say that beyond counsel of choice, even with the denial of the license, I appeared today as a jurist from Jumuiya to observe the proceedings. And because I remain a lawyer, whether the Law Council approves my license or not, I am at liberty to wear my attire to identify myself as a lawyer. And therefore, I came robed. My robes are not a criminal offense. My robes are a result of the training I have had. And nobody can strip me of my robes unless if I commit a criminal offense, which I have not. We are here today joined by a fellow jurist from Kenya. Let him just say his name and one word, and then a jurist from Angola will identify herself.
Kieme Gesheru is my name, an advocate of the High Court in Nairobi. I have put in my application to the Law Council to be enjoined into this matter. And we are going to follow it up until it is done. We are going to comply, we are going to appeal, we are going to push until it is granted. There's an issue that I'd like to address. Being in Jumuiya, we are very intertwined. There's something that has started happening in Nairobi, which we never had seen. Masked men abducting people at night, and we have had many killings in Nairobi, having masked men roam around during protests. Now we've realized where the source is, and that's why we are here, to root it out from the source. We have never seen this in Nairobi. We have never seen this since the regime back in Nairobi started. But it's been here. And this is why we are here to root out this ill in society.
Your names again?
Kieme Gesheru.
Kieme Gesheru.
Kieme Gesheru.
Yeah.
Thank you very much.
A word from my sister from Angola, a human rights jurist from Angola.
Hi everyone. I came here as an observer for this trial, this court session. As you may be aware, trial observation is an instrument to ensure human rights to fair trial and access to justice. So I will not get into the details of the session, but I would also add that my presence is a sign of solidarity, is a sign of there is a need for us as human rights defenders in Africa to join and be together, raise our voices, be creative as well, and stand up against brutality, against authoritarian regimes, and defend the rule of law, which is the basis for guarantee human rights. So my presence here is to support all those lawyers, professionals, human rights defenders, but also be before the court and make the court accountable to the principles of the rule of law. Thank you.
Okay, finally, I just want to say to the Law Council, kindly, no double standards. If you could allow the President, Yoweri Museveni, to bring Kaminwa from Kenya, Dr. Kaminwa, my senior, for a civil matter, a criminal matter is more serious than a civil matter. That involves the life and liberty of Dr. Besigye and Mr. Lutale. No double standards. What's good for the goose is also good for the gander. Let them review their decision. We are going to contest it, and we expect that they will not apply double standards.
If you look at Swahili,